But if you go out there and make me look like a fool for giving you an opportunity, it's not going to go well. You understand that? I'm talking because I don't know what I'm going to do with you right now. Because I don't disagree with either attorney here today.
Right out of the gate, Judge West makes it clear she's not here to play games. This isn't just a warning, it's a subtle legal power move. Defendants and their attorneys immediately understand the stakes, mess up, and the full punishment range looms.
And this is cause number 26 DCCR 0112. Mr. Jackson was previously in court, entered a plea of guilty to aggravated robbery. There was no agreement in this case. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor. Stay as Judge.
Are there any additions or corrections?
Not from the defense, not from the state judge.
Right, Mr. Rojas, you may proceed.
Thank you, Your Honor.
And rule on it if you want.
I realize, Judge, we've got a problem with guns in this county, and more specifically in the city.
I mean, the gist of it is...
I don't know that anything we do here today is going to solve that problem. Certainly there are things you can do to deter other people watching this and see what happens to young people with guns. But I think there are some people who are not going to learn their lesson until they go to prison and spend a certain amount of time there.
Notice how the judge distinguishes between different types of defendants. Some are hardened and won't learn lessons until prison, while others might be deserving of a second chance. This is classic judicial reasoning, balancing public safety with potential rehabilitation.
There are some people who are going to go to prison and never going to learn that lesson. They'll just spend their life in a revolving door, coming into court, prison, in court, back to prison. And there are those that, for whatever reason, the circumstances they find themselves in their life, they make bad decisions, make mistakes, and are deserving of a second chance. He was raised by his mother and his grandmother. He lost his mother, I think he was 15 when she passed away. His life went into a downward spiral from there.
Your Honor, you know where I stand on these kind of cases, so I won't belabor that. But what I will do is point out what I consider to be aggravating factors in this case, Judge. And despite Mr. Rojas's argument as to what mitigation there is in this case, I believe the aggravating circumstances outweigh any mitigating circumstances. And what I'm getting at is the fact that this defendant robbed at gunpoint with another co-defendant who was also brandishing a firearm, a 16-year-old, took his iPhone in front of that 16-year-old's 5-year-old niece, Judge. Can you imagine the trauma to that 5-year-old to watch her 16-year-old uncle get robbed at gunpoint, Judge? And with regard...
Here comes the shock factor. The victim was only 5 years old, and the defendant committed robbery at gunpoint in front of them. Emotionally, this is a devastating detail. Legally, it's an aggravating factor that dramatically influences sentencing.
To the firearm that this defendant used, it was a P80, Your Honor, for the courts, in case you're not familiar with that. Polymer 80 firearm that comes in a firearm kit that is partially complete. Doesn't take much to make it a functioning firearm. The thing about that is the ATF calls those guns ghost guns because they have no serial number. I submit to the court.
The P80 ghost gun explanation is key. These unserialized firearms are a growing concern in the legal system. By highlighting this, the prosecution emphasizes not just the crime itself, but the dangerous tools used, a subtle way to justify stricter sentencing.
What does a defendant, in this case, at the time, a 17-year-old defendant, need with a firearm that does not have a serial number, Judge? So for those reasons, I say that any mitigating circumstances are outweighed by those aggravating circumstances that I just referenced. And I'd ask the court to sentence this defendant in accordance with your sentences in other similarly situated cases, Judge. Thank you.
Start any process.
Thank you, Mr.
At this point.
Coleman.
It was filed today.
Mr. Jackson, these cases are hard for me, and I know Mr. Rojas has told you what's been going on and what's been going on in this court, and I'm sure you're aware of all of that.
Again, that's going to be just on hold.
I find your case
Your Honor, may I
a little bit different
one more matter?
than some.
I was in court at 9
But,
o'clock this morning for docket.
Not
And
the guns are the biggest
10:20
concern
to look at my
for me
email
and
on
for
cell
everyone.
phone To find that there's a motion
And
to compel
the
discovery.
using
and for
them in a
any
way
review of the state's file And
like
the
it's no big
only
deal,
thing that I
and
would
everybody
like to
having them at
address
15,
regarding this
16,
motion at
14,
this time
whatever.
is that it refers
I
specifically
appreciate
to the 11.072 motion.
the fact also,
and
though,
appears
that
to suggest
you've
that
never
the
been
state,
in trouble.
has not
As a juvenile, you've never been in our
has
system.
not complied with
You
discovery. And this is a
Figured
motion
out
to
real
revoke
quick that you need to
probation.
follow the rules
I
in
did
jail,
provide
because I'm sure word got
discovery
out
to
there is
the,
people are talking about the fact that
defense
that
counsel
is something
on the
that really
motion to
affects
revoke,
me
as
and what
well
I
as the
do. And so I
administrative
appreciate the
hearing,
fact that you've gotten your act
which I'm not
together out
generally
there.
required to do, but I do to be helpful. And also the pre-sentence investigation report.
And I'm talking because I don't know what I'm going to
So-
do with you right now,
I
because I
also
don't
like to
disagree
respond to
with
this
either
motion
attorney here today.
to compel, as I said, I just briefly
And that puts me in a
skimmed it,
position
but
where
those
I've got, my
items
job
stood
is two things. Is one to,
Well, based on your.
well, more than that, really.
The
One is to protect our community. Another is to punish. Another is to rehabilitate. It's something
guess
where
what I
I have to
understand,
potentially
Mr.
take
Biden, is why this
chances
is
that
being
makes
filed
me
today.
sometimes
We're here
uncomfortable.
for a hearing. We're here to.
It
we're
looks
going
like that
forward with
before your mom
sentencing
passed
today.
away, you were doing really
Ms.
well
French has
in school, playing
represented
basketball,
to the
right?
court that she has provided discovery with
And that's a
regard
hard thing to
motion
go through,
revoke, which
especially
is
at your
what we're here
age.
for
But you
today.
can't let something
There's
like
already been
that
a plea on that underlying offense,
get
so
you
we're
where
going
you are
forward
now,
with the motion to revoke.
right? What would she
hearing
want
on
you to be
sentencing at
doing?
this time.
Not this.
I'm not going to
Right?
sign or grant any motion to compel. Sounds
So
like
does
they have
grandmother live
already
in the same
complied,
neighborhood where all
with
this took
everything they're
place?
required to do, plus
Stay with my
to give
grandma.
you whatever information.
You live with your
you need
grandmother,
with regard
but does
to
she
going
live
forward
in that
with this
same
hearing.
neighborhood? Is
We're
that
gonna
where you
go
were living
forward.
when this happened?
Yes.
So.
Not literally,
the
but
argument in
neighborhood.
the motion
Some
as well
like
is
How far away from the those apartments do you
and
live?
I can
2
tell the
blocks.
court, like, since it's an unadjudicated case, I believe that the standard discovery rules apply, and discovery is not limited to just the administrative documents and the.
Do you have anything you want to tell me?
The motion to adjudicate guilt or the motion to revoke unadjudicated.
Apologize to the
probation.
victim and the victim family.
That
Who put them in this situation.
she is here being sentenced on the underlying offense. And
All right, here's what I'm gonna do, Mr. Jackson, and I hope that you don't make me regret this.
So
Because here's what's going to happen. I'm going to give you a probation. There's going to be all kinds of conditions on this probation. And because there was no agreement, the type of probation.
Deferred probation with heavy conditions. This is the judge giving a structured second chance. It's a mix of mercy and strict oversight. Watch how she layers fines, jail time, mandatory programs, and living restrictions to create a roadmap for potential rehabilitation.
That I'm going to give you means that if you violate it, I'm going to have the entire punishment range, which is between 5 years and up to the rest of your life. You understand that punishment range? I can tell you this, today, if I had sent you to prison, probably would have been in the 15, 20-year range. If you're back in here after I give you this opportunity, it's not going to be that.
1107 matters, which have their own kind of.
I can't tell you what it'll be. I don't know. It'll depend on what all's going on. But if you go out there and make me look like a fool for giving you an opportunity, it's not going to go well. You understand that? I want you to succeed. You've got family here. They want you to succeed. So what I'm going to do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings. You will be on probation, on a deferred probation for 10 years. I'm going to order a $500 fine. I'm also going to order that you serve 3 months upfront time. And so after that 3 months in our county jail, you will then be ordered to enter and successfully complete the cognitive track of the ISF program. And let me tell you what that program's for. It is to help you make better decisions. You need to pay attention there. You're still young and your life is going to be very different. You're not going to be able to do everything that your buddies are doing. You're going to have to follow these rules, because if you don't follow the rules, you're going to go to prison. They may or may not. So you're starting off your early adulthood very different, and you either make a conscious decision to change and grow up and be mature about it, or you end up in prison. It's that simple, right? Once you get out of ISF, you'll live with grandmother. I'm going to order that you are ordered to live with her at her house until I order otherwise. So you get a job, you want to get your own place, you want to go live somewhere else, you don't get to do that without my permission. So you don't get to go hang out other places. You're home every single night. You will have a curfew. If you're not there and you're caught not home when you're supposed to be, you're right back in here and you could go to prison. So I'll do what I can to put the rules there. It's up to you to follow them. Make sense?
I would feel more comfortable, Your Honor, if we address
Obviously, a
these
condition
things
of your
before we have a
probation
sentencing hearing
is that you are not allowed to have any firearm at all. You cannot have firearms at your disposal. So if there are firearms at grandmother's house, they either have to be under lock and key or removed from that house. I can assure you, if you get in trouble with a gun again, it's really not going to be good. Okay? This is your chance. I hope you take
Curfew, restricted movement, and firearm bans. Judge West is drawing a clear line. This isn't just about punishment. It's a teaching moment. The judge wants the defendant to understand the real consequences of choices in his early adulthood.
it and this changes your life. Because this type of probation that I just gave you means you do not have a felony conviction on your record. So if you have a felony conviction, it changes your life really bad in a lot of ways. You can't get certain jobs, you can't go to certain schools, you can't live certain places, even apartments. Sometimes they don't let convicted felons live there. So you don't have a felony conviction right now. But if you violate, you're back in and you do. So you kind of have a clean slate. And it's up to you to keep it that way. Okay? I'm handing you the trial court certification that shows this was an agreement. Or there was no agreement, actually. You do have some rights to appeal. You can talk to Mr. Rojas about that.
Judge, I would ask that the court consider making a condition of its probation, no contact with the co-defendants.
Yes.
And I was looking for the names of those co-defendants. I can't find this.
It might be in here. So, Mr. Jackson, you are to have absolutely no contact, no communication whatsoever with Dale McDonald, okay? And also, obviously, no contact, no communication with the victims in the offense. You're not to go near that street or their house. So if that's the way you normally get in and out of the neighborhood, you've got to find another way to go. You cannot be anywhere near that area. Do you understand?